Thanks for joining us today. We are talking about fraud and concealment in New York workers' compensation cases. And what a perfect day to really be talking about this together. We're going to be talking a little bit about what workers' comp fraud is, how the law defines it, but really this could not be more perfect timing for us to be talking about fraud in the workers' compensation context. And I know some of you are saying, wait, Greg, why aren't we talking about the eclipse? Well, I'm going to do this entire presentation with my eclipse glasses on today. I can't see anything through these things, so I'm thinking these are legit glasses. I'm hoping I wasn't defrauded by the person I bought these off of on Amazon. We've got the eclipse coming here around 3 o'clock Eastern time, and I'm going to be running outside to check that out, and I hope everyone has their glasses and is ready to go. But our topic today is fraud, and it could not be a more perfect timing. Last month, a fraud complaint was filed alleging that both workers' compensation attorneys and medical providers and even some political entities and political organizers and social clubs have been engaged in a massive conspiracy to defraud workers' compensation insurers in the state of New York. If you look in today's handout materials, I included a copy of that filed complaint. And it is huge. It is massively long. If you're one of our clients, I've already sent you an email talking about who are all the parties that have been added into that fraud complaint and what we're going to do about it and how we think this is going to impact the defense of claims in this state. And so I'm going to touch on that a little bit in today's presentation. Our goal today is really to talk about fraud in a workers' compensation context, but this could not be coming at a more interesting time. And if you're interested in what's happening in that construction case, I would tell you, Google ABC News, 7 on your side. They've done a number of videos that have been on local TV stations talking about the amount and the rampancy of fraud in the New York workers' compensation system, and particularly in the construction context. So if you're interested in that, please take a look at the complaint, which I added in today's handout materials. Take a look at some of those videos or those news pieces that have been airing locally. And I can tell you, it feels like we've reached some sort of tipping point in the state. In fact, my partner Noah says this is the tipping point. This is the place where it's become so rampant. And again, particularly in that construction context, that now it's making the news. And you can't watch a news presentation without them talking about this. So what a perfect time for us to be exploring this and talking about it today. Please, thanks for joining. Let's talk about what we're going to look at today. We're going to talk about what is workers' comp fraud, how does the law define fraud, what are the penalties, how do we defend cases where we think there's a potential for a fraud defense in the case, and we're going to talk a little bit about where we see this being most prevalent. Now, this is a completely and totally live presentation, and in your screen, if you're attending live, please feel free to ask me questions. I do intend for this to be interactive, and what I like to do is I like to go through all the prepared materials, and I do have about 30 slides to go through, kind of talking about the definitions and how this is applied in this state. And then my intention is to answer as many questions as I can. When I answer questions, please don't tell me the case names or case titles. Please ask them in a general sense, and I'll answer them in a general sense as best I can. I will only say your first name so you know I'm answering your question. I will then read your question for the whole audience so everybody gets the benefit of that question, and then I will do my best to answer your question. This is the main benefit of attending these live, and today we've got almost 100 people live so far. So please feel free to answer your questions. If you're watching this back on videotape or you're just listening to the podcast, you don't get the opportunity to ask those questions. So please do it. It definitely makes this much more fun for me, and I think it can make this more interesting and useful for you today. All right, so let's dive in to looking at fraud. This will be a general overview, and then we'll talk specifics. So the definition of fraud in this jurisdiction is lying about any material fact for the purpose of getting any kind of benefit. And the section of the statute that we're always referring to is section 114A. Section 114A says the claimant has to make a knowing misstatement or representation as to any material fact in the case. So let's talk about what that means and what we have to show. I have to present, in order to prevail, and this is what the case law says, I have to present substantial evidence to support a finding that the claimant knowingly made that false statement in order to obtain workers' compensation benefits. And before you say to yourself, whoa, that's a really high bar or threshold for us to surmount in order to be successful in raising fraud in the case, and don't worry, okay? It's not that big of a bar, because substantial evidence has been shown in the case law to mean any evidence that's more than nothing, okay? So it's not just an accusation or an allegation, it's anything that I can present that shows that the person made a misstatement of any type of fact. I need to demonstrate that there was some sort of misstatement. What's the most common thing I'm going to point to? I'm going to point to things the claimant themselves already said, right? So I'm going to be pointing to things they either told their treating physician, told our evaluating physician, or put forward in a pleading, right? That's what I'm going to be relying on. I also have to demonstrate that they were making these misstatements to obtain some type of benefit. But it doesn't have to be just a money benefit. It could be medical treatment that they weren't entitled to. It could be reimbursement of medical care. It doesn't have to just be money moving, right? Sometimes we think of fraud as only involving money, but no, it's involving any benefit that they've received at all. If I prevail and demonstrate that the claimant did commit fraud, they made a knowing misstatement of fact in order to obtain a benefit, the only benefit that gets stopped or terminated is our obligation or responsibility to pay them money in the future. So that's the only benefit. And what that means is that if the claimant is shown to be a fraud, that they have a lack of credibility, that they were hiding their condition, that they concealed prior injuries to the same body part, right? That's a misstatement of fact. Concealment of a pre-existing condition is concealment. That's per se definition of fraud. The only benefit that gets stopped is their entitlement to future workers' compensation benefits. Money stops. And some of my clients say, well, that's not really that satisfying, Greg. I mean, we proved this person's incredible. We proved they were a fraud. We did our job, and they're still entitled to medical care. But here's what we've seen. Our experience has been, once you stop the money, they stop receiving medical care. So even though that exposure is maybe not fully terminated with the finding of fraud, who cares? Because they didn't need that medical care anyway. It wasn't getting them any better because their whole case was a fraud. They're incredible. They were hiding their condition. And when you stop the flow of money, generally we see that they stop pursuing that unnecessary treatment. So it really does have a very powerful impact on the case. A lot of times when we talk about fraud, we talk about covert surveillance, but I want to talk a little bit at the beginning about non-covert surveillance. Covert surveillance is that type of surveillance or investigation. It's directed either by the adjuster or the attorney, usually begins after the workers' compensation case starts. And what we're doing is we're assigning an investigator to follow them around or videotape them or try to obtain or create proofs that we think would be useful in defending a case. But just as powerful, and I'll tell you that in general, we're just as successful with what I'll call non-covert investigatory materials. Non-covert materials. What am I talking about when I talk about non-covert materials? General observations, published or known facts, information that we're obtaining about this person. And one case that I like to talk about is the case of Dubrell versus Maplecrest. Dubrell worked at a car dealership, and he claimed that he was disabled from a work-related accident. He did receive medical treatment and compensation. And when it came time to determine his permanent residual disability benefits, he claimed that he had all these restrictions. He said he couldn't do any of the things that he enjoyed doing prior to the workers' compensation laws. And now we knew that Dubrell owned a horse farm. And he claimed in his testimony that no, he wasn't able to do anything with the horses anymore. In fact, some of the horses he was raising for other trainers who were going to use them in horse racing, particularly harness racing. And in that case, the interesting thing was the adjuster who was actually assigned to the case knew a couple things about horse racing. And even though we assigned covert investigation to him and surveillance, we were never able to find him engaging in any horse racing or training of horses or taking care of horses. We didn't observe it. But this adjuster was quite savvy, and she knew that, hey, horse racing has its own newspaper, for people that are really into gambling on horses, I guess. They keep up to date on that stuff. And what she was able to do was find in the horse racing journals, horse racing news stories about this guy racing horses. And in fact, he won harness races while he was collecting workers' compensation benefits. So we were able to go to court and show that he was published in the newspaper as winning a horse race while he was allegedly collecting comp. So that is not covert surveillance. That's non-covert. That's information that we obtained. It was generally published, and it was useful. Okay, what's a great example of that now? Social media posts, right? People that are publishing things about themselves all the time. The big question with the social media posts and the types of things that people are putting out into social media that we have when we're defending these cases are, how am I going to get this in court in front of a judge? What is my document? What is my witness? How am I going to present this? What we're doing in our cases now, when we have a suspicion that the person's engaging activities that exceeds what the limitations that they're telling their treating physician is, we're demanding access to their social media. And in the beginning, I was demanding that the person provide us with access to their social media posts by either friending an investigator or opening up their social media and making everything public so that we could see it. But back in 2018, we said, wait a second, they're not really working because people can delete things from their social media, they can hide them. And beginning in 2018, with a case that has become now really the landmark or the Semina case in this, which is Vincent Joya versus the Township of Pleasantville Fire Department, we argued that the judge should require the claimant to give us access, not just to their social media, but actually give us their social media passwords. And the reason we did that in the Joya case was because we knew that he was putting things out on Twitter, but then when we went to collect them, he was deleting them. And what a lot of claimants are maybe unaware of is that even when you delete something from Facebook or Instagram or Twitter or Snapchat, it still lives on their servers. And if you have access to the person's account through their logins, you can go and undelete all their posts. So now when we have this suspicion that there is a potential contradictory evidence in their own social media, what we're doing is filing a request for further action, asking that the plaintiff turn over their social media passwords to us for the limited purposes of determining if they are engaging in activity which is contradictory to what they told their doctors or our independent medical evaluators. And that has been consistently upheld by the Workers' Compensation Board as something that's appropriate for us to ask and to obtain. And we've obtained that. So if you're wondering how we get that in front of a judge, that's how we do it. All right, let me tell you about another case I had involving non-covert testimony. And if you've ever come to any of my fraud presentations, you know this is my favorite case of all time. And it goes back more than 10 or 11 years ago, but it's going to be in my slide deck probably until the day I retire. It's always been in my slide deck. And it's the case of Douglas Becker. Douglas Becker was a claimant who alleged that he injured his knees while working for us as a pest technician. We put surveillance on him after he told his colleagues that he was engaging in professional wrestling and defending his world cruiserweight title of professional wrestling, and invited them actually to come watch him wrestle. And we did put surveillance on him, but we were unsuccessful actually in capturing him doing any professional wrestling. Until someone shared this with us, which was an example of Douglas Becker, who wrestles professionally under the name Ladderface or Atom Flash. And here he is in a ladder match. This is our claimant at the top of the ladder. There he is engaging in this professional wrestling match. And again, we didn't capture this on surveillance. This was posted to his social media. And actually, it wasn't posted directly to his social media. It was posted to the social media of his girlfriend, who at the time also wrestled, and she wrestled under the name Commissioner Jugs. So Commissioner Jugs posted this stuff on social media. It does concern him. It's videos of him professionally wrestling. And we were able to rely on that to get the case ultimately dismissed. So that's another example of non-covert surveillance, something that someone else is posting about you on social media, which is, again, one of the reasons why this can be so useful. Now, Section 114A, the section that allows us to raise fraud in a workers' compensation case, this might blow your mind, but it was only added to the statute in 1998. I guess prior to 1998, everybody was honest and there was no fraud in the New York workers' compensation system, presumably. But it's a powerful statute because there does place an affirmative duty on the claimant. They have to tell the truth. And they can't have someone else be untruthful on their behalf. So your claimant who goes to their appointments with their spouse or significant other who's telling the doctor all of their limitations, well, that person can't lie on behalf of the claimant or be asked to conceal material facts. They have to disclose all their activity, even if that activity is not paid. So doing things like coaching a little league sport or engaging in a charity drive or leading a civic or a social organization or religious organization, all of those things count as work under the fraud statute. They also don't have to receive any money in order for it to be deemed a fraud. They just have to receive any benefit at all, which could be their own enjoyment or their own contribution to a charity. Any benefits that we've already issued on their behalf must be stopped. And generally speaking, once the judge of compensation finds that the claimant has been deemed to be a fraud, these are incredibly difficult cases for them to win on appeal. So when they go on appeal and they go to the board panel, or they go on to the appellate division, they say, well, the judge was unfair. I'm not really a fraud. Those things that came out in the case are just, they're not right. They're not fair. Let's give me a redo. In general, the board panel and the appellate division is going to say, no, the opportunity to observe the testimony of the claimants or listen to the testimony of claimants and to judge the witness credibility, that really is with the judge of compensation at the trial level, and we're not going to disturb it. And they're very reluctant to overturn those cases. So if you do win on fraud before the Workers' Compensation Board, it's going to be very difficult for them to overturn this. And you can see if you follow us online or are connected to us on LinkedIn, I mean, we're posting fraud wins almost weekly on our LinkedIn just to demonstrate to people how much fraud is actually going on in this system. So let's talk about what is fraud. Obviously, working while collecting temporary total disability, whether you're working as a professional wrestler or any other job. How about collecting passive income? So claimants who also own businesses and are receiving business income because they're participating in a business, that can count as fraud and that can count as income. Also, unpaid activity on a new business, that is work. In the Angora versus Wegmans case, Angora claimed that he was totally disabled from working for Wegmans, but video surveillance found that he was literally building a bar that he was intending on opening and was opening a tavern. His argument in that case, which is kind of clever, he said, well, Judge, I wasn't working. Yes, you do have video of me running plumbing and piping and literally building a bar inside this tavern, but that business hadn't opened yet. That was purely speculative. That was really just me investing my time. I wasn't getting paid for that. And the judge of compensation saw right through that and said, come on, you're opening a business, that's work, right? That's work. Some more examples of fraud are, how about just making up the accident or staging the accident? In situations where the claimant has given a version of events concerning the mechanism of their loss, mechanism of injury, and then determined later to have simply staged the accident. I mean, that's a clear example of fraud. Failing to disclose prior injuries to the same body parts, that is fraud, even where the prior injury is not work-related. And this is probably one of the most common things we see, the concealment of a prior pre-existing condition. And I'm just going to stop for 1 second and just take a little bit of a right-hand turn here. Employees that are bringing workers' compensation claims are required to complete an employee claim form. It's a form C-3 in our workers' compensation jargon. They have to sign that form, and at the bottom of that form, they have to admit if they've had any prior injuries to the same body part. What we've seen is a real trend where most claimants are affirmatively not filling out that employee claim form. In fact, even though it's required, certainly the board will assemble and index a case and let the case go on and have hearings and maybe even determine compensability without the claimant actually ever even filing that form and signing it. In every one of the cases that we defend, we're going to want to make sure that the claimant absolutely fills out that form and signs it, because often that will become the affirmative pleading that we're going to point to and say, look, Judge, we found out that they had this prior claim. We found out about it because we used our ISO, Insurance Services Organization, Prior Claims Index Bureau report, or we searched the docket, or we found medical records which reveal a prior injury. And Judge, they left it off their employee claim form. That's the per se fraud. Okay, so we're failing to reveal that is an example of fraud. How about misrepresenting their activities of daily living, right? That's one of the most common frauds we see, where they're telling their doctor, what do you do all day? Oh, I just lay in bed writhing in agony. I'm in so much pain. I can't do anything anymore. I'm totally uncomfortable because of this workers' compensation law. And then, of course, you put your surveillance on them and you find them going about their normal day, driving their car, going to shopping stores, going to restaurants. There's a really funny meme going on right now on TikTok, which I'm not a TikToker, but it was brought to me, where an investigator was following around a claimant who was allegedly totally disabled and found her going to stores while she was allegedly totally disabled and actually shoplifting. And one of the stores she was shoplifting from was actually the prior employer. So that was all captured by the surveillance agent. So those types of activities, which, when you watch those videos, sometimes they're not that compelling or exciting, can be very useful for us in terms of determining or arguing that the claimant is committing fraud by concealing their actual abilities from their treating doctors. Some more examples. How about being a criminal? There are many cases where the claimant was actually charged with committing crimes, including the sale of prescribed narcotics or other drugs, while they were collecting temporary total disability. And while that's happening, you should make an argument. Hey, how come they're well enough to be engaged in the drug trade, but they are not well enough to go to work? So if you find that your claimants are engaged in criminal activity or arrested, or you find that there's a lapse in care because they've been arrested, look into why. And that might be an avenue for you to find an allegation of fraud. Another example of fraud, this is the classic. You come out of the doctor's office, we have you on video, you pop the trunk of your car, you take off your neck brace, you throw your cane into the trunk of the car, and all of a sudden you're fine, right? So that's a great example. And we'll typically see that in the context of a covert investigation. Now, let me tell you some of the best practices to help us detect fraud and then also present the case in court, because it's not just enough to find fraud. That's not where the story ends from my perspective, because remember, I'm always talking or looking at litigated cases. So when you're thinking that there's fraud in your case and we are considering doing a covert investigation, my recommendations are to always do or to plan for a multiple day covert investigation. I also request that we use a different investigator for each date. I'm not interested in investigation reports. Now, I know some of my clients say, Greg, I love those reports, and unless we get those reports, how do I know the investigator who didn't maybe observe the claimant did their job? Okay, I get it. You want reports so you can keep your investigators honest. So if reports are a must, then my position is no multiple day reports. I also think we should be working together to come up with the best time for surveillance. Why these best practices? Why do I make these recommendations, which I think these should be standard in every case, in every jurisdiction, everywhere we go, but let me explain exactly why I think these are the best practices. So let's say you don't use my best practices. You get reports from your investigator, you use the same investigator, and you do multiple days of surveillance. Well, the first thing that's going to happen is your investigator will be cross-examined with their own report. I don't like that. I don't like the investigator having to be forced to sort of explain all of their observations and be drilled on that. The second thing is, it's very typical for, if you do a multiple day surveillance, that many of the days, maybe 5 days of surveillance, maybe it'll only be one day when you're actually going to get good video of this person. I mean, this isn't a knock on investigators. I think by and large, they do an excellent job, and it's just really challenging. Sometimes the claimant doesn't leave the house. Maybe there was something really good on TV. Maybe there was a Yankees game on at 1:30, and they were going to be inside all day drinking beer and watching the Yankees. So there's nothing to capture, right? That's not a knock on the investigator. But what does become a problem is when there's 4 or 5 days of surveillance, but only one good day of observations, the claimant's attorneys are prepared to say, well, that was a good day that you caught them on. And there's a lot of bad days. Look, Judge, they watched him for 5 days, and only on one day was he mowing his lawn, jumping on a trampoline, going to the gym, whatever it is that you have captured. And Judge, you should assume that the other days were all bad days. And as stupid as that is, and as counterfactual as that is, unfortunately, it's compelling, and the judges kind of go for it because, again, they want to give the claimant the benefit of the doubt. And in those circumstances, the length of surveillance actually works against you. Typically, the first question my opposing counsel is going to ask of the investigator is, how many days did you watch my client? And if the the investigator is speaking honestly, they say, well, I was hired to do 5 days of surveillance. Okay, how many days did you observe my client? Well, one day. One day he came out of his house and I was able to capture his activity that day. Okay, and so 4 days, you were there for 5 days, and the other 4 days you didn't see any activity. No, I did not. Well, isn't it possible that those other 4 days he was in so much pain he couldn't even go outside of his house? Investigator, speaking honestly, is going to say, yeah, maybe, I don't know, I didn't observe them. I have no idea what they did those days. And again, the length of surveillance works against you. So if you do my rules, again, I don't want the report, and I would like a different agent each day. First, with no report, there's nothing to cross-examine the witnesses with. Easy. Second, we're only going to introduce the videos and only introduce the agents who observe the claimant. That means that every agent I put on there is going to say, I'm going to lead with this question. Hi, I'm Greg Lois. I'm the defense counsel. I represent the employer in this case. How many days did I ask you to follow the claimant? Now, the agent is going to have to answer honestly. They're going to say, 1 day. I was retained for 1 day of surveillance. I'm going to say, okay, did you make observations? Yes, I did. Are all of your observations contained in the video that you produced? Yes. Did you edit, change, or in any way augment the video that you've produced? No. All right, Judge, let's play the video. It's going to stand for what it is, which is a complete portrayal of what this investigator saw on the one single day I retained them to observe the claimant, right? This eliminates the good days, bad days defense that opposing counsel loves to engage with. Because they can't confront them and say, well, how many days in total was this person placed under surveillance? Well, the witness isn't going to know. They can't answer the question. They'll say, well, I was only retained for 1 day. So you eliminate all of the potential for your surveillance video and your surveillance information to be undermined. So I think these are good rules, and I think these best practices work in all circumstances, and I think they should be deployed. Now, fraud is both strategic and tactical. In terms of strategic, it could close your case, and tactical because it can create leverage in your case. So it's strategic because if you win, you foreclose your exposure for future payments. And if you prevail on it, you might even be able to argue that you should be reimbursed for the amount of indemnity you've already paid. You can also refer the claimant for a criminal prosecution because insurance fraud is a crime in New York. And as I stated at the beginning of this presentation, once the money stops flowing, the medical usually ends. But it's also tactical because the way fraud is introduced in a workers' compensation is I raise fraud as a defense counsel. I don't reveal the supporting evidence, whether it's covert or non-covert, until after the claimant testifies. That means that as soon as I raise fraud, well, now all the parties, including the judge, know, hey, Greg's probably got something in his back pocket, but they don't know what it is. And the claimant has to go on the stand and testify. And I'm going to ask them all sorts of questions. I'm going to be very specific about how I'm going to back them into a fraud corner. What we've discovered is even when you don't have great fraud proofs, you can raise fraud. And sometimes I've had my opposing counsel or their clients say, well, okay, we don't know what you have, but we know the guy's been doing a couple things. And all of a sudden they start telling the truth about the person's actual workability, which again is useful. It's also tactical because if you raise fraud in a workers' compensation case and you do not prevail, the judge says, I reviewed all the evidence, I observed what was portrayed in the videotape, and to me, this was not compelling, I don't find fraud. Okay, that does not foreclose you or stop you from later in the case, 6 months later, as treatment has continued to progress, raising fraud again and doing it all over again. So there is no real downside, even when you don't have strong fraud proofs, to raising fraud in a New York workers' compensation case. You can raise it over and over again. All right, so some do's and don'ts. I believe that you should raise fraud at the earliest opportunity you can, as soon as you have evidence that could sustain the argument. I do not want us to wait too long to raise fraud. And in fact, I've sometimes heard attorneys say, well, we've got good video so far and it's looking pretty good, but let's get some more video because we want to get an even better fraud argument to raise. That's too late. I think you're wasting time and you're not being as aggressive as you should be. There's also case law that says if you wait too long to raise fraud, in fact, after their claimant has already testified, it's too late to raise fraud. So, once you've allowed the case to go to final proofs and the judge is going to make their decision and we're waiting for a reserved decision, and then you decide, well, you know what, let's raise fraud now, it might be too late. So be careful about that. When we are raising fraud, we should carefully plan a cross-examination. We want to start really big. We want to end really small. The claimant is going to be, their testimony is going to be the basis of our fraud argument. And what I like to do is start real big. I start with real big picture questions and I move more and more specific, deeper into the cross. Our process here is to plan these cross-examinations. I do not do them off the cuff. I've been at this for decades, but I still don't go into a fraud prosecution case with I'll wing it based on what I watched on the video. And in fact, we think the best process is to write out the cross-examination plan in advance and actually to mock trial it a few times to make sure that it's strong. What we want to do is start real big picture and get narrower and narrower the deeper we get into the cross-examination to entrap the claimant most specifically. I'll give you an example. I had a case in which the claimant had a right shoulder injury, arthroscopic repair. We thought he had a pretty good result, but of course his doctor kept him out at temp total forever. We had videotape of the gentleman driving in his car with a canoe on top. I'm sorry, a sit-on-top kayak. It wasn't a canoe, it was a kayak, like a plastic kayak. Drives it to a local lake, reaches up to the top of his vehicle, unties the kayak, gets it off the vehicle, carries it on their shoulder, puts it in the lake, and paddles away with their sit-on-top kayak, having a great day. It was a beautiful sunny day. When I cross-examined the claimant, and I've got that in my back pocket, we raised fraud, obviously, because they're telling their doctor they can't work, and their doctor's finding a temporary total disability, and we've got them kayaking, right? It's a great, easy case. You don't need Sherlock Holmes to bring this case. But you want to start really broad, and so we start with what are you able to do? Are you able to drive? Well, how much can you lift? How much can you raise your arms? You told your doctor that you can't touch the top of your head, that you're having difficulty raising your arms above your head. You start real big, you start real vague and large, and then deeper into the cross-examination, about 15 minutes in, I start saying, well, you do have a blue Subaru Outback station wagon, don't you? Yes, I do. You also own a sit-on-top kayak, don't you? Yes, I do. You are able to go kayaking, aren't you? And in fact, on May 5th, 2024, isn't it true that you were able to take the kayak off the roof of your car by yourself, unassisted, carry it to the lake, and go kayaking for 2 hours? Isn't that true? You end with that real specificity, the real clear example that you have in the videotape, but you start really broad. And by doing this, you're building a good record and you're preparing yourself should the claimant try to appeal the case. So we do have a process here for starting with those big picture questions and then moving it into more and more specificity as you get deeper into the cross-examinations. Now, when we're cross-examining the claimant and they're testifying about their abilities or activities of daily living, We can't let them weasel out of it and use lawyer words. And, my pain comes and goes. Sometimes I can, sometimes I can't, right? Or when it's real bad, I can't touch the top of my head. Okay, how often is it really bad? You've got to tie them in, and you've got to narrow them down, and you've got to draw the walls in and make it as specific as you can. Our opinion is that you should not signal where you're going in your cross-examination until the last possible moment. You want to leave the judge with this real specific activity that the person claims they can't do. And then remember, after they testify, that's when the video gets played for the first time for all parties. And if it's real specific that they're doing the thing that you walked them into saying they can't do, you're going to be in a great position for raising fraud. And the other thing is, the opposite has happened as well, I should say. The opposite is, I start cross-examining someone about what I know they can do, and all of a sudden they're admitting to all sorts of other things that they can do, so it makes my case even stronger for me. Confront them with as much documentation as we can locate and obtain. The substantial evidence that we're going to produce at trial is typically going to be the statements that they've made to their own treating physicians. So when we are bringing one of these cases, we're going to want to have a really great reference to the statements that the claimants contained in the medical documents and records, which are already part of the court record. I don't want them to come out and be able to say, well, the claimant's incredible, or the claimant lies, but I still find that they have an overall disability, right? That's going to be an instant appeal. And I don't want them to be able to claim that they didn't understand my questions, right? They'll say, oh, well, your question was misleading, or I couldn't understand the question. That's why the fraud cross-examination has to be planned. It has to be very careful, and we're going to be very specific about what we're talking about in those types of cases. We want to keep the end in sight when we're thinking about fraud and deploying it successfully in a case. Tactically, most times we raise fraud, the case resolves into a compromise or a settlement. Sometimes strategically, we can win a complete dismissal of the case, but there's other strategic uses of our fraud allegation, which is, hey, you're warning your other co-employees that, hey, we're not going to tolerate this. We're not putting up with this. And sometimes in the self-insured or high deductible context, we want to be even more aggressive about this because we don't want to encourage co-employees to bring workers' compensation cases where they know that their colleagues are gaming the system, right? In the Douglas Becker case that I first talked about, the reason that fraud, or that we began to suspect he was a fraud, was not because of some legal strategy we had, or because we were on top of everything from a medical perspective. It was because co-employees were coming forward and saying, hey, Dougie, he hasn't worked shifts here in like 6 months, and it's weird because he's asking me to come watch him do his other job, which is performing as a professional wrestler. It was the co-employees who were annoyed because they were having to pull overtime and cover his shifts that went forward to the managers and said, can you guys do something about this? So let's pay attention to that. Your good employees are going to become disgruntled employees if they find that people are scamming you and taking advantage of you and preying upon you as an employer. So that's also something to just keep in mind. We want to be mindful of our goal. Is it tactical? Are we just trying to create some leverage in this case? Or is it strategic? We think that by raising fraud in this matter, we might get the entire case dismissed. All right, before I move into questions, let's just do some quick summarization here. You can win on fraud stuff, and you can raise fraud, particularly in your how mucher cases, the nature and extent or degree of permanent residual disability or the degree of temporary disability, by conducting these investigations and raising fraud. My opinion is we should raise fraud as soon as we possibly can. I think it's better to raise the issue and at least get some tactical momentum in a case than it is to wait until you have the perfect fraud proofs. So we want to be pushing these cases forward. Now, the advocacy that I'm talking about is within your control, right? This is one of the few times in the workers' compensation context, particularly in New York, that we will be in the driver's seat. And this is an opportunity to get ourselves into the driver's seat in these cases. So if you're frustrated with your New York workers' compensation cases and you feel like, hey, I'm getting taken advantage of, this whole system is not, we're not successfully moving these cases to conclusion, consider this as an avenue where you can be active and proactive in your matters in order to really get some leverage and get some momentum in them. So I think it's useful for that reason. All right, let's move into some questions and answers. Hoping that this was a timely and topical presentation today. And I'm going to open up the question panel now and take a look and see what we've got. Okay, so I got a couple here so far. The first one comes from Gene. He says, is Greg sharing his screen? I only see the initial screen. Uh-oh, that's not good. Well, I hope everybody was able to see my screen. It sounds like Gene had some issues with that. Let's go back. Alexander says, Greg, when the New York Workers' Compensation Board finds both the mandatory and discretionary penalty on a Section 114A, does the Office of Workers' Compensation Fraud Inspector General always get involved, or is that on a case-by-case basis? Okay, great question. So no, the Office of Fraud Inspector General does not jump into every workers' comp fraud. They don't have the manpower or human power for that, okay? No, generally speaking, where it's egregious or where there's a strategic reason to do so, we will then forward on the proofs to the Inspector General's office and ask them to take the case on or to prosecute it. So, and that is up to their discretion. And frankly, they do not have the manpower to look into every single fraud case. I wish they did. But as you're seeing now, this is really coming to a head with that tradesman case, which I put in today's handouts, because there's not just workers' compensation fraud perpetrated by the claimants. The allegations in that case are that there is a group of conspirators, and it starts with attorneys. It's spreading now. Now they are looking into some of the legal funding companies that may be helping build these networks. And it's also being participated in by the physicians and the medical providers. So that's really where this is going to really, I think, grow over the next year or two as they start to look into medical providers who, for example, are copying and pasting the exact same physical therapy treatment notes for all patients that they're treating across all of their service branches, and they all look the same and there's no change from week to week. Those types of things are also fraud, and they are also coming to light and really coming out now. So there's going to be more of this, and I think the Inspector General's office is going to be even more busy than they've been in the past because of that. Okay. Christopher says, Greg, I have an employee with a checkered past with many ISO hits. ISO is Insurance Services Organization Claims Index Bureau reports, which shows all of their prior claims. They're complaining they can no longer wear work boots, and they have a claim of a rolling ankle, etc. Just don't want to wear work boots anymore. The doctors restricted them to sitting work only, and they should be allowed to wear sneakers. But that's not an option because of our scope of our work in the workplace. The claimant is currently out of work and not sitting. We have it on good authority that the employee is completing renovations at their home. Surveillance was already completed, but they became aware of surveillance. How do they go about arguing fraud when they have a restriction of sitting work only? Obviously, everyone needs to walk from the grocery store to the car. How do we argue they're committing fraud with such an unfavorable or vague restriction? Okay, so you've got a couple things going on here. First one is, can we nail down that restriction? Why don't you get a functional capacity evaluation? Why don't we use a defense medical expert to really suggest what is this walking restriction? I mean, what is this really? The idea that someone can't walk, period, is ridiculous. Obviously, they're getting around. You know that's happening. So that's number one. The second thing I would suggest is you have the suspicion that they're working on their home. They're doing renovations while they're sitting home not working. And surveillance is a great example, a great way to go about looking into that. But here's another way. Why don't you go and see if they've pulled any permits for their home renovation? Who's the contractor? Who's doing the work? Are they doing the work themselves? That's another avenue. And again, that's not covert, right? Pulling permits, studying to see what's being delivered to their house. Are there work materials? Are there building materials being delivered to the house? That type of stuff is not really covert, right? You could be going and pulling publicly accessible work permits or and any of those types of things, and look into it that way as well. So that sounds to me, Christopher, like one where you'd want to get really creative, because they have a very vague work restriction, and you've got a strong suspicion that they're doing something to violate it. Lisa says, Greg, we caught a guy on surveillance delivering bread for a bakery between 4 a.m. and 11 a.m., and he testifies he was doing it to help a friend. The workers' comp judge did not suspend benefits. How can we win against a judge who refuses to see the light? Okay, this is why we have appeals. That's appealable. I mean, working a 7-hour shift delivering bread, that's a job. And helping a friend, that's a benefit, right? You're doing, which I don't believe, by the way. I'm sure their friend was paying them under the books or some under the table, or some other means of exchange was going on there. But that to me clearly looks like workability. 7-hour shift delivering bread. I mean, that's not something that no one says to themselves, hey, I've got the day off of work today. Maybe I'll go hang out with my friend and do a 7-hour shift doing bread delivery. That doesn't sound fun. So that's definitely one I would look into. Lisa also says, Greg, have you ever seen the treating doctor or IME doctor? Have you ever sent, the treating doctor or IME doctor their surveillance footage to compare to the medical treatment? Absolutely, I do. Particularly where the surveillance footage is not that compelling, where they're telling the doctor, I can't get around, I can't drive my car, and you've got video of them not doing anything exciting, but they're definitely driving. Why wouldn't you confront them with that? And I've done it both ways. I've sent it to the treating physician and said, look, this person that you're treating says that you keep saying they're temporarily totally disabled. Here's a video of their day. We have 45 minutes of them walking their dog, checking the mail, they could do something, right? They're not totally disabled, correct? So, be mindful about it. Now, once you've done that, though, once you've revealed your covert investigation to the other side, essentially by giving it to their doctor, it's out there. So it loses its value, its surprise value in the trial. But sometimes it's so compelling on its own that it doesn't, maybe you're not worried about the surprise value. All right, Rachel asked a question. One thing we often see when trying to raise fraud from the C3, that's the employee claim form, saying no prior treatment, and the attorneys are saying it was their error. They filled it out and put the wrong information. Is there any way we can fight that? Yeah, sure. It's a signed pleading, okay? You're not supposed to sign things that are knowingly wrong. And by the way, that's really easy if you're their attorney to just say, hey, before I sign this on your behalf, and by the way, that's countersigned by the attorney. They generally don't sign the form by itself. It has to be signed by the claimant, and their attorney countersigns it. They're supposed to verify all that information. They should not be filing false pleadings. That's unethical. So you might have an ethics complaint to raise against that attorney, which again, that will help you create leverage in your case. Brian asked the question, Greg, can doctors be held accountable for treating fraudulent claimants? Yeah, absolutely. That's the basis of this tradesman's claim. I mean, I think the insurance company and tradesmen's realizing that these medical entities, which when you really take a look at the ownership of them and the naming structure, there really is some collusion, looks like, is going on there. They're going to be held liable, and their argument is that they were overbilled for millions, for tens of millions of dollars for medical treatment, which either A, never actually took place, or B, was completely unnecessary. So yes, the doctors are going to be held to the account for participating in a fraud or furthering a fraud. Michelle says, Greg, I have a claimant who was injured the date of the alleged workers' comp accident, but the emergency room report revealed a different story of the facts of loss. He had a fight and was pushed down the stairs by one of the guys he was having an altercation with. He fractured his right elbow. Will workers' comp still let him get medical treatment? The emergency room record is definitely not work-related injury. No, you've got maybe a staged fight. I mean, look, that's one of the stories as old as time, the person who gets injured on the weekend playing softball and then comes to work and reports that as a work injury. And it sounds like what you have is someone got involved in some kind of physical altercation with somebody outside of the work context and is trying to say, oh, this was actually work-related. So it sounds like you have a staged accident, a per se fraud that did not occur. That's one where I would certainly look into that more carefully. So yeah, that's definitely something we see, particularly the instance of the Monday morning accident where nothing was reported and they got injured, maybe working on their own home in the weekend or doing something voluntary and try to portray it as a work accident. So great questions, good questions from everybody. Thanks for bringing them. Let's wrap this up. So I just want to give everyone just a quick heads up. if you're interested in this kind of information, go to our website. You can sign up for our newsletter. We do publish 4 podcasts a month on different aspects of workers' compensation law and subrogation. You could check out my partner Christian's podcast. It's called Third Fridays, which, as you can imagine, it's because it's released each month on the third Friday of the month. And that's really like a 201 level discussion of workers' compensation topics. So again, I hope this is useful for you, and thank you for allowing me to participate in your learning today. Have a great day, everybody. Enjoy the eclipse, and I'm going to leave you with just me wearing my eclipse glasses. Okay? All right, be safe. Don't stare at the sun. See you next month.